everyone. Good afternoon. So I'm delighted to welcome our keynote speaker, Professor Chris Ashford. So Chris Ashford is Professor of Law and Society at Northumbria University in the UK. He's also Chair of the UK Quality Assurance Agency 2022 for the law subject benchmark review. He's a member of the Research Excellence Framework 2021 subpanel for law. Professor Ashford was a member of the UK Standards Board Pathways Qualification Task Group 2016-17 and the BSB Academic Stage Working Group 2015-16. So Professor Ashford has been at the heart of the research assessment exercise in the UK for law, as well as the development of pathways to professional qualification. But Professor Ashford is also co-editor of The Law Teacher, as well as being a prolific researcher himself. So Chris will draw on this experience in his keynote speech, which considers the challenges and opportunities in publishing legal education research. He seeks to demystify the process of publishing and the decision-making process, including peer review. So as always, if you have any questions for Professor Ashford, please put them to me in the chat box and I'll read them out at the end. I think this talk is especially timely for us, as the next stage for many of us, having given presentations in this conference, might well be to publish in The Law Teacher or some other legal education journal. The title of Chris's talk is Publishing Legal Education Research. Chris.
Many thanks, Michael. I will share some slides with colleagues, which I hope will be useful. There we go. So thank you so much for inviting me along today, and good morning from Newcastle upon Tyne in the northeast of England. It really is wonderful to be with you. And I'm hoping today to provide some practical advice as well as some academic insights into publishing legal education research. And I'm going to talk about a number of areas today. I'm going to talk about thinking about legal education research. What does it look like? What does it mean? And the different options in terms of getting published. When we talk about publishing, we immediately take on a whole series of assumptions about what that final piece of work might look like. I want to talk through what those different options could be and what that might then mean for how you design the research itself. I'm going to talk about what journals are looking for, particularly drawing on my own experience as co-editor of The Law Teacher. Again, is one of those things that seems to become mythical, that people get very worried about what a journal is looking for. I hope to demystify some of that and give some insights as well into the peer review process, what reviewers are looking for, how that all works, how decisions are ultimately made on work as well. And then I want to spend a little bit of time talking about quality thresholds for research, particularly in relation to Rev 2021 here in the UK, but also drawing on RAE 2020 in Hong Kong, which is very, very similar to the UK thresholds. And these really offer some sense of what it is that the wider legal research community is looking for. And I guess that alludes to a question in a previous session that I caught the end of just now for Michael Lower's paper, where people were asking, you know, are we part, as legal education researchers, are we part of an education community or part of a law community? And I think it is worth noting that for most researchers, not all, but for most researchers, when it comes to assessing that research through these frameworks, then legal education research is typically positioned within legal research. And I think that is perhaps worth reflecting on as well. Delighted to pick up any questions on that later on too. So these different forms of legal education research writing? Well, we might immediately think peer review, gold standard, that's what we're talking about. But actually, legal education writing could take a number of different forms, and these forms all have value in their own right, and also can form part of a pathway towards publishing peer-reviewed articles as well. So let's start with blogs, something that have been around probably now for about 20 years, with people writing pretty extensively in this area. I'm thinking of international scholars like Paul Mahag in particular, based in Australia and Canada, and previously in the UK as well. Someone who really shares their work in progress. Blogs can be incredibly useful for doing that, and also sharing the pedagogic practice that people are engaging in, and providing therefore a reflective tool as part of that exercise. These can sometimes be collaborative. The Association of Law Teachers, for example, hosts a blog, and that includes a number of sessions from the Connecting Legal Education community that some people at this conference may be part of. That international community shares some of the work in progress through the blog, and that allows engagement, reflections from a wider community. And of course, it also forces us to crystallize our thoughts. It forces us to think through, what are my claims about this practice? Why should anyone care about what I've done? What is interesting about it? And what that might then mean for how I can show that I know those things. I know the impact that the research has had. How do I prove that? How do I design that in? A form of legal education writing that certainly is part of the law teacher, and something that many of you may have engaged in, is book reviews. Now, the law teacher, like many academic journals, has a review section, but our review section is particularly focused on the perspective of a law teacher. So how might this particular text be a useful resource for law teachers, or indeed for law students to engage with? Traditionally, that might be a textbook, and what's innovative about it, what pedagogic features does it have, how are those innovative, how are those useful? But it could also be a monograph, a research monograph. You're seeking to draw on some of the philosophical ideas that might be there. Now, again, in writing this review, one, it is a useful experience for writing in a more academic style. Law teacher reviews are relatively short, at about 800 words, but other journals, they could run up to 1,500, 2,000 words. In some US journals, perhaps up to about 3,000 words. As well as giving you that experience of academic writing, the reviews also do force you to think through those theoretical questions, those pedagogic questions, and again, therefore, inform what you might be thinking about as part of a wider piece of work about innovation. So, for example, you might be thinking about a particular theoretical perspective in your own pedagogic practice. You might be wanting to produce a longer form article developing those ideas. Or you could tease out some of your initial thinking by writing a review of a particular work that engages with some of those theoretical aspects, and that allows you then to tease out some of those themes in a review setting before embarking on a longer form academic article. Of course, one of the areas that we see a huge growth of in recent years is online commentary, policy commentary, which really seeks to capture some of the rapid changes that are occurring within the broader higher education context. Online journals like The Conversation, which is international based, can be very useful. Conversation articles are often republished in high profile international newspapers, online journals, and that can therefore garner quite a lot of attention to your ideas. And I guess this is one of the other aspects of legal education writing, out with peer-reviewed academic articles that I haven't touched on so far, which is this can also be a useful way of getting your name out there, getting your ideas out there, so that people might be therefore more inclined to contact you, to share with you their own ideas, their own practice, And that can lead to fabulous collaborative work, which of course can then be resulted peer-reviewed academic work, and can make that work a little bit easier if you have a collaborator, if you have someone who shares your viewpoint, shares interest in a particular aspect of empirical work, for example. And then the final aspect when it comes to legal education writing is, of course, peer review itself. I think there are a few things that are as helpful for getting a sense of how peer review works, how we might reflect on the quality of draft work that comes through as undertaking peer review yourself. Those opportunities are often advertised through scholarly societies or through journals themselves. Other times journals might have a less transparent policy. They might simply be recruiting people who have particular sets of expertise. They might, particularly, again, common for some of the big journals, as part of the submission stage, ask you to nominate other people as potential peer reviewers that then get added into their peer review college pool. So again, if you want to get into those opportunities around peer review, it is about looking out for those opportunities when they're advertised, and it is about, again, having some name recognition out there, becoming known for your ideas so that other people might put you forward for it. For the law teacher, we do something different. In the last few years, we've introduced a system of a peer review college, and the intention behind that is to make this process a lot more transparent for people. So we have regular calls that are inviting people to put forward a self-nomination to be in the peer review college that asks you to simply set out your expertise, what it is that you would bring to that reviewing experience. We recognize that everyone has to start somewhere, so you might not be hugely experienced in undertaking review, but we would then team you up as part of that experience with people who are more experienced, and we also provide workshops to share insights into good reviewing, bad reviewing, how we can provide constructive reviews, and so on. So some journals are seeking to make this a much more transparent process. If you are interested in becoming a reviewer for the law teacher, then do feel free to reach out directly to myself after this conference, and I can connect you up with one of our deputy editors who's leading on that work. And hopefully we can then, if you're successful in your application, fold you into the next recruitment round of briefings to advise you on the process and so on. So do look out for those opportunities. As I say, other journals will advertise from time to time, and I think the journal community is getting better at supporting one another through peer review, but it does give you a really great insight. So different forms of research articles then. So if we then do think about this peer review, scholarly articles, the longer forms of writing that could be between 6,000 words right up to around 10,000 words for most UK, Australian journals, a little bit larger than that, particularly for US, North American journals up to perhaps 15,000 words. For these peer review pieces, I think in the past, there has been a temptation when it comes to legal education research to think of this as simply sharing something you have done that is interesting and telling the world about it. As legal education research has become, I think, more sophisticated, has become more established as a field over the last 40, 50 years, I think that has evolved. And certainly for the law teacher, and I think for most pedagogy-based journals today, we would expect more for that. We would expect people to have a sense of methodology and a sense of method within that. And that is to say, a particular theoretical viewpoint that you might be bringing to your education work. We would expect increasingly an empirical dimension to that research. We would expect that it has been tested. We would expect that that empirical work is not simply a cohort in your own law school, but actually might draw on a number of law schools. So again, that speaks to the idea of collaborative work and forging those networks and connections. We would expect that empirical work to adhere to the rigors that would be expected of any other type of legal education research or legal research more generally. Indeed, any research that we might find within the broader social sciences or humanities. Therefore, it might not necessarily be empirical, it could be theoretical, or it could be a fusion of the two, and indeed, particularly rigorous pieces of work probably would be a fusion of empirical and theoretical. It could be comparative, multiple jurisdictions within that, but not simply saying I'm comparing one law school in Australia with one law school in Hong Kong. It would actually be based and rooted in rigorous comparative methodology. So going to the literature around how one does that. An area that we've seen a little bit more sophistication and emergence of in the last few years is autoethnography. And not simply saying I'm going to share my own reflections on my own experiences, but actually rooting that within the rigorous methodology of autoethnography, which is developing at pace and is a really exciting area. I think in legal education research, we have been a little bit more familiar with action research, and increasingly we're seeing more theoretical work, particularly in English language focused legal education research around feminist queer perspectives, and similarly critical legal scholarship. So some of the theoretical ideas, feminist work, for instance, or critical legal scholarship, those theoretical areas that you would see in broader law research, we're seeing applied in legal education research. So where am I targeting? Thinking about the journal, the focus, the audience that you're bringing to this is super important. I'm going to talk a little bit more about that in a moment. When we're engaging in peer review, we are reviewing, we're not auditing in the ref sense. I think sometimes there is a fear when we submit our work as part of peer review that it's going to be someone who says, well, this isn't good enough, or this isn't 4-star research, to use some of the ref or RAE language. Actually, what we're talking about in peer review is, what is this person trying to do? How can we make this better? How can we improve the rigor of this particular work? To what extent does this piece of work speak to originality and significance? And again, I'm going to talk about that more in a moment. But the principal aim of that reviewing exercise is really to be supportive, to make our work better, and therefore to make our discipline a better discipline in research terms. Of course, for legal education research, there is an additional pedagogic aspect to much of this. And therefore, when we make our research better, we make ultimately our pedagogy, our law teaching better through the rigor of that research. It informs future practice, perhaps our own, perhaps the practice of others. It may, of course, particularly theoretical or policy work, inform strategic directions for our own law schools, for our own leadership, for the a particular jurisdiction, the particular approach, the evolution that a particular jurisdiction is facing as well could evolve. And alongside that, I think that raises some questions about how do we know these things? I think we are seeing an increase in research training, particularly through communities like the Legal Education Research Network, the Connecting Legal Education Research Community that I talked a little bit earlier about, the Association of Law Teachers, and you've also got law teacher associations in many other parts of the world too. Of course, add to that, institutional support is improving. I know that our hosts for this particular conference are doing some fabulous work in developing support structures around research training as well. And more generally within legal research, we've seen a huge growth around the world in doctoral training in recent years, either through traditional PhD routes or increasingly through taught doctoral routes or professional doctorates. That research support can be institutional, it can, as I'm touching on here, be external as well, but crucially is about mentoring and supporting colleagues. And this knowledge is, of course, beyond simply our own narrow experiences, but is rooting it clearly within broader scholarship. Those of you who have been involved in the advanced HE framework will probably be a little bit more used to this, setting out our own experiences, locating it within theory, and so on. So these opportunities then to publish can typically be open call. The Law Teacher, for instance, is just an open call journal, like most peer-reviewed journals. You can submit at any particular point, but you might also have opportunities for special issues. Special issues is where a journal chooses usually to have a guest editor and to focus on a particular issue. Now, earlier on, I talked about getting a reputation, getting known for a particular area of expertise. Special issues can be a fantastic way of doing that because anyone reading it will be focusing on the particular area of focus and interest of that special issue. So it can very quickly help you to become established in that area, but also it can bring you together with other collaborators, with other people who share your area of interest as well. So special issues can be really supportive and helpful opportunities, sometimes linked to 1-day, 2-day focus conferences as well. They are really super useful opportunities to look out for. However, there is a tension, a pressure that we all face increasingly, which is that of the predatory journal. You, I'm sure, have emails from various journals that are asking you to publish with them, not always in any area of your own interest, let alone even your discipline. I frequently seem to get chemical engineering journals inviting me to publish in them. These are journals that, of course, are simply seeking to hoover up your material, or indeed put things behind paywalls and con people into paying for them. So do go for respectable, established journals, or journals where you know through colleagues, through your own networks, the pedigree, the quality of the journal that you're seeking to publish in. It'd be very flattering getting an email asking you to publish with some journal that is bigging itself up. But if you've never heard of it and you don't know where it's being published, do be cautious. Fundamentally, therefore, understand the journal and the section that you are targeting. You'll notice that much of this is coming back to that idea of a network, a community that really runs through all of this in helping you to produce your research, to publish your research, and to know the publishing landscape. And of course, that community, that network, can also be a way of providing guidance on your work and also looking informally at your work to provide insights before you submit a piece for formal review. And so establishing those trusted colleagues who would be willing to look at your work in draft form can be extremely useful as well. In the UK context, when it comes to research excellence, we have the Research Excellence Framework, which has been around for a number of years now, most recently the 2021 framework, the results of which were published here in the UK last month. The 2014 report made a particular challenge for legal education research. It noted that legal education research was pretty inconsistent. It had some issues that it needed to address. And the June 2022 REF report has made a similar recommendation. So reflecting on the most recent exercise, has said that, as noted in the REF 2014 subpanel, methodological rigor and significance exhibited by some of these outputs remains uneven. The subpanel welcomed the emergence of clinical legal studies as a growing field of research in the UK. So those of you within legal education research who focus on clinic, there were some positive messages from REF 2021, but legal education research remains singled out for lacking some of the consistencies that one would expect in other areas. So the challenge in terms of rigor, in terms of methodology, remains for legal ed research. And I think you'll see that in terms of the quality expectations of journals increasing in the next period. So certainly it's happening for Law Teacher. We are scrutinizing method and methodology much more. We are expecting authors to engage with multiple samples when it comes to empirical work, for instance. So we are no longer publishing any work that simply draws on one institution. It needs to draw on multiple institutions, for example, in order to expand the rigor of that work. And again, I'm happy to pick that up in the questions in a little bit of time. The Hong Kong RAE 2020, the most recent similar exercise in Hong Kong, managed by the University Grants Committee, is very similar to the REF in the UK. So we can see, for instance, 70% weighting for outputs in Hong Kong against 60 in the UK, 15 for impact against 25, and 15 is the similar for 2. So the point of putting those stats up, don't worry too much about them, is to simply highlight that outputs is really the focus for these research excellence frameworks, whether that's in the UK or in Hong Kong, and indeed it's similar in the Australian process for sure too. So outputs, articles are going to really matter for law schools. They're thinking about putting legal education research in as part of their submission. So the quality of what we write in legal education research for articles matters. And it matters then in this assessment that focuses on very similar language, whether this is in Hong Kong or in the UK, around outputs and their originality, significance, and rigor. And that's what I want to focus on some more. So when we think about originality, and this particular text on the screen is taken from REF 2021 in the UK, originality is understood as the extent to which the output makes an important and innovative contribution. And on it goes to describe that a little bit more. But you can see that we're talking about new or complex problems. We're talking about innovative research methods or methodologies. We're looking for imaginative and creative scope. So if we're thinking about writing up your legal education research, and we're thinking about this question of originality, why should someone care about your work? What is it contributing to the field? Is it that you are replicating a previous study, in which case that limits inevitably the originality of your work? Not to say there's not value in it, but it limits the originality. If you are doing something that nobody else has published on before, then that is likely to be original. But how original is the methods, methodology, the data sample that you are seeking to bring forward? So really thinking about that originality, how you're contributing to the field, is super important. And that does link to the significance of your work. How likely is it to shape and influence the discipline? How is it going to support knowledge and scholarly thought? And as I mentioned before, for legal education research, that's really important because it can go on to inform our own pedagogic practice as well. So the significance of the work has to be understood in parallel to the originality. And then the key element that is super important here too is rigor. And this, I think, is the area that legal education research has struggled with the most, because here we're talking about really the robustness of our work. So when we think about, for instance, empirical work, how big is our sample? Why is it the size that it is? What does that say about the ability to access a particular research population, for example? What process have we gone through in terms of the ethical design of a particular study? If it is our own law students, then inevitably that raises questions about how they're responding to us, how they're responding to the research design. Is it focus groups? In which case, who's run the focus groups in your law school? Is it the person who's delivering the same teaching that is being analysed, discussed within that empirical work? Well, clearly there are going to be questions about that. On the other hand, if you're engaging in survey data, how are you going about that? Generally in legal research, there has been less training in quantitative methodology, and so we tend to skew more towards qualitative work. That in itself is not necessarily problematic, but it does mean that there is an extensive literature in legal research around qualitative methodology, and therefore we have to be familiar with it, we have to engage with it. So I think you're getting a sense here that the rigor, the originality, the significance is really important and increasingly important for legal education research. So what does this all mean in practical terms? Well, for the law teacher, we have a number of sections for our journal. We have policy and education developments, a relatively short section of around 1,000 words, and that provides an opportunity for people to share some of the current events that are happening within legal education. So those policy questions, those questions of new events that have happened, new developments that might be happening in training approach, for example, can be covered in our policy and education development section. We also have learning resource reviews, which are our book reviews section, and I talked about the opportunities for that earlier on. And then we have an article section, which is our peer review articles section for the journal. So you can see those different styles that we talked about. You can get those different experiences with the law teacher, like many other journals as well. And when we're going for articles, then we are going for those originality, significance, and rigor, those characteristics. We can see that if we had experience of other writing, it can start to provide us with a framework towards producing that work if colleagues are less experienced at doing so. But through all of those areas, we are asking these questions. We're asking, what are you seeking to say, to whom, and why? We are also asking, what are you saying that's new, whether that is a review of a book or it is a academic peer-reviewed piece. That is a question that we should be asking. Something that I've said before, a slightly crude question perhaps, why should anyone care? But it is a question that reviewers will be thinking about, and it does again speak to significance and originality. And what is the reader going to do with this knowledge? That can really shape the significance of the work. And I think it's important for legal education work. Is this going to be something that is going to change pedagogic practice? Is someone going to read your particular article and say, okay, I'm going to do something different? A really common example of the challenges that legal education research is facing at the moment is around technology, for example, whether that's in the context of COVID or that is part of the broader technological evolution that we're seeing in pedagogic practice around the world. Those questions, if we get the work right, can really shape and influence the work of others. But it is a crowded area. So understanding the existing literature, understanding the existing theory, and precisely what you're contributing is super important. And you can see, therefore, that with the opportunities of some of those areas also comes some particular challenges. I'm conscious of time, so I do want to speed up a little bit, but I do want to just flag up that for the when it comes to thresholds, we can really look at some similarity across both the Hong Kong system and the UK rep system. And I've drawn here on the Hong Kong RAE 2020 descriptors of 4-star, 3-star, 2-star and 1-star research. Research in the UK exercise was similarly graded, and I think if you look at the descriptors, they are remarkably similar. So 4-star in both jurisdictions, exercises focused on world-leading research, and indeed one colleague from the Hong Kong exercise is also on the UK exercise. There is a lot of transferability across the two. But when we were looking at 4-star research, we're talking about agenda setting, primary or essential points of reference. So when we're pitching that originality and significance of our article, if we're aiming for that work to be the very, very best, then it is going to be a primary or an essential point of reference. It is going to have novelty in its thinking about concepts or results. So you can see that most of us are probably not going to be writing 4-star research. We should be realistic about how we think about these thresholds. But 4-star research can be done. It is likely, therefore, because of that originality, to be done very occasionally. It's not something we'll be doing all the time. And it's something, therefore, we probably also need to think about, again, collaboratively in order to ensure that we do hit that threshold. Similarly, in terms of 3-star, we have got that emphasis on originality. Again, but we also have that it's an important point of reference or makes important contributions that have a lasting influence, has significant influence. So you can see it's not quite the top, but still when we think about 3-star research, there is a demanding set of standards. And when we come to 2-star, we're talking about a recognized point of reference of some influence. So even when we're talking about 2-star research, it is going to influence others. So when we're thinking about writing up our legal education research, who is it going to influence? Why? What's the impact it's going to have on the area? Why is this going to be valuable research? Produce valuable knowledge. But perhaps it's incremental in the advancement of knowledge that it's going to provide, rather than really a paradigm shifting piece of work. And then 1-star, which is in both exercises the lowest threshold to meet, a panel will grade the research for having limited originality, significance and rigor, if there is some evidence of or potential, some of the characteristics, and really we're talking here about useful contribution or minor influence. So even 1-star is going to be useful, it is going to make some contribution to legal education research in our context. So when we're talking about the peer review college that I mentioned earlier, for the law teacher, it will probably have in its mind these thresholds in terms of what is the best research, what is 4-star, 3-star, 2-star, 1-star, and so on. But that is not the evaluation decision of a review. It might be in your head in terms of thinking about the best research, but you are actually thinking about how are you supporting this work, how could this work be better, what is it doing in terms of its contribution to the discipline more generally. And we ask our peer review college to provide a clear recommendation of accept, minor amendments, major amendments, or reject. And we ask our reviewers to also provide an informed and robust review that contextualizes the submission within the field. So if you're thinking that that's what a reviewer is going to do, you can preempt some of this. You can preempt it in how you craft your abstract, how you craft particularly the introduction to a piece of work, where you're setting out why your work is important within the context of what you're writing on. So for instance, you might be writing an empirical piece on reflective practice within legal education research. Well, if you set out in the abstract and or the introduction very clearly why this is significant in the area of legal education research, specifically in the context of reflective writing, how is it contributing to existing literature, existing theoretical work in this area, existing empirical work, what is it doing that is original and significant, and what's the rigor, what's the method and methodology that you've applied and how is that rigorous? You can see you're also providing for a reviewer that context and also providing a clear sense of the quality of the work that can help a reviewer. So knowing what a reviewer is thinking about can also help us to shape and craft our work to make it better to speak to that process. So to wrap up and provide some time for some questions then, in both the RE 2020 and REF 21, we've seen international standards set out, and those standards also apply to legal education research. However, those research exercises are not the only game in town. To use a euphemism, they are not simply the only evaluative tool for legal education research. There is value in our work in legal education research, as I said before, that can really inform pedagogic practice. There is work that might be an article review, a blog or a commentary piece that might not be eligible for REF or RAE, but is still a useful piece of work in its own right, and or could also be a piece of work on the way to other forms of research. These different forms of research writing in legal education are important, but whatever we're writing about, I would suggest thinking in terms of originality, significance, and rigor can be incredibly helpful for how we think about this work. I will stop talking at that point and open this up for some questions. Thank you for listening.
Many thanks, Chris. That was wonderful. First of all, we've got a question from Jessica Kutin. Let me just get this question. Yes. So the question is, just wondering, for interns, law students, which blogs would be good for them to publish in, especially if they write something about the utility of their clinical or research placements? Which blogs would you recommend?
I think that's a wonderful, wonderful question. And of course, one of the interesting things is that student journals do tend to emerge and fade away. They tend not to have that sustained platform, because it tends to be a group of students who are particularly excited about an issue, who might get their own law school to create a blog or platform that provides a space for it. You can have forums, for instance. So I'm thinking about the as the name has gone completely out of my head, the clinic journal that is based here at Northumbria that is online. If you go to Northumbria Journals online, you'll see it listed there as one of our journals. But our clinic journal, for instance, does often have a forum, and that's provided a platform for students to share that voice that is like a blog platform. So those forums can exist in a number of formats. As I say, I can't point to a particular blog for students because they tend to come and go. As a group of students says to a law school, we'd love to do a blog, or they create a blog on WordPress in their own right. That blog might get a particular bit of traction because it's plugged into other social media, whether that's Instagram or Twitter, and so on, and different audiences and different demographics will engage with different platforms and provide different audiences in. But then after 2 years, then it's typically 2 years, because a student might do it in their first and second year on a 3-year undergraduate program, and then in the third year focus on other things, focus on their typically their final assessments, or on a 4-year degree program might do it in the second and third year before a 4th year that specializes in practice, for instance. So you can see how you then have that critical mass of students who would step away from it. So my advice would be for students who are engaged in that, or for colleagues who know students who are engaged in that, either to direct them towards platforms that provide forum spaces within existing journals, and more open access online journals which have more flexible platforms are doing that, or alternatively then to encourage those students to create their own platform. But I do think it's important that that is connected up with other social media platforms so that people engage with it. Really, it's why is a student wanting to do that? What is the value in it? It is about engagement. Of course, those resources, those blogs, can also then provide fabulous resources for academic colleagues to engage with, to enrich their own pedagogic practice, but also then to provide essentially a data point for research that people want to produce as well. So there are a range of options there. If you can't find one, do it yourself, but also think about how these platforms can be incredibly useful for a range of opportunities.
Esther Erlings has just direct messaged in to say the journal is the International Journal of Clinical Legal Education. Esther's sent the link, but I'm not quite worked out the magic that will get the link into the chat box. I'll try and do that later. And that just to say, so Jessica, is that okay?
Yeah, no, I think that's great. I think that comment about not enough quantitative legal kind of academics or people working in that, we get interns at our foundation and we kind of get them on a little research project. And I'm thinking now, yes, they need to come out with a little output, be it a blog or something like that, either about their internship or either about some area of social justice, civil law that they're really interested in, and have a solid output in there for themselves, as opposed to just being a little smidgen on part of our various research projects. So thanks, Chris, really got me thinking.
Now, many moons ago, I did write a piece on blogging as well, which is published in before I was editor, which was published in the Law Teacher, that you might find interesting to look up. One of the really interesting things for student blogs is that sometimes students write in isolation. So students are very keen to write an output, but less keen to read other people's, right? Which is something that's reflected in many legal academics, right? We like to write our own work and chat about that, but engage with it less. Actually, the real richness comes in reading one another's work. And I think for blogs, then enabling that to reflect on a shared experience that can often be felt. And so suddenly you think, oh, that way that I was feeling about this experience, other people were experiencing as well. And so you can then get another level with blogging. So rather than it being a single reflective piece of writing, that if it's people sharing that experience through a whole program, for instance, or even just on a module over a year, you can see an evolution because people are actually engaging, reflecting with one another throughout that process. So yeah, blogging can be a fabulously rich tool.
Yeah, thank you.
Could I just join in that conversation? Because in one of in an elective I taught, we tried to train people to write blog posts. So we looked at the criteria of a good blog post, looked at the Australian version of the conversation, some legal articles there, and one or two people actually blogged. We've got a blog I'm going to tell you about at the end of the conference. But we did find when we used blogging in teaching, and I know you've written about this, Chris, is that it is really difficult to get students to know how to comment on blogs. So I do think perhaps the next stage, having taught people how to blog, the next stage will be to educate people in how to participate in blogs, how to keep a conversation going in a positive direction, and the value of that, the social value of that.
Absolutely.
Then Esther said we should share this law teacher, so I'll do that in a second. But one thing I wanted to do, Chris, I wanted to first of all say, any more questions, please put them in the chat to me and I'll read them out. But one thing is, Chris, what you said about publishing in the law teacher, in a certain sense, sounds forbidding, because it sounds as though you've emphasized the need to draw on theory, and that was I was talking about that in the presentation you came on earlier. But also when it came to the perhaps a preference for quantitative and then kind of large scale quantitative, and yet I know that the law teacher publishes research is empirical, but it's qualitative and small scale, and saying, okay, this is what happened in this very local context, and then saying, of course it's limited, but it may be relevant to you. And so would you agree that is another approach that's acceptable?
So I think that, so you're absolutely right, Michael, in terms of the publishing pathway around this. I think another point that I didn't mention here is that there's a gap between what a journal is publishing and what a journal might be seeking to have come in as material. So for the law teacher, that's about a 1.5 year gap. So from something that comes in to when you see it in a print, you're probably looking about a 1.5 years. So from the law teacher, it's a bit like an oil tanker changing direction, therefore. So when we as an editorial policy say, actually, we're not going to publish any more of those kind of articles that are small scale, that only deal with a single institution. There is value in that work, but as a journal, we are going to focus on larger scale work, because we are getting repeatedly signals that legal education research needs to have that rigor from these exercises. And if we are not doing that, then there is a real risk as a legal education community that the institutions in which people are based will no longer view that work as work that is equivalent to other areas of legal education research, and therefore it will not get support for people to go to conferences, it will not get support for people to have research time to produce that work, and it won't be viewed in the same way within the academy. So for the legal education research community, there is a job as a journal to ensure that that subdiscipline is rigorous, because we want it to have vitality. We want it to be an area that is successful. So you're right that there have been smaller studies published in the law teacher, and there still will be in the next few months because of that pipeline. But we have made a conscious decision not to produce smaller studies. I think the Journal of Legal Education in the US, for instance, has been there for some time, but I think it's been easier in the US context to have those large scale pieces of work. In the UK, we've been less comfortable with doing it, same in Australia, and I suspect similarly in Hong Kong, because they're relatively small jurisdictions or small numbers of people doing the work in that. But you're seeing therefore more theoretical work that provides more depth. You're seeing more empirical work, which could be qualitative as well as quantitative. I picked up on quants because there's less done on it. I myself am more comfortable with qualitative work. I'm not trained in quant, so I would run a mile at the prospect of doing a quantitative study. But I do think there's a need for us to scale up our work. And if we're struggling because we're in a small law school, we might not have those networks. I think that's a new challenge for us to build those networks, to look at comparative work, to have the rigor there, or a number of institutions in a jurisdiction that are focusing on an empirical aspect.
Because I'm just thinking though, so it's very practical, this conference, because we, because of course what like message might be, well, the next stage from the presentation is to submit to a journal like Law Teacher. And so I just want to make sure the message is clear. So what you're saying is that by and large now, studies that don't involve larger scale quantitative data are unlikely to be published in the Law Teacher.
I think that's right, Michael. I do think it depends on your population. So for instance, if you're dealing with law teachers who have faced racial discrimination in a particular university context, or have faced particular issues about, for instance, challenging a government organization or a government perspective, then you are probably dealing with a hard to reach small data sample for that, a small population. So that is relatively to be a smaller sample that you're talking with, just as if you were dealing with any other research population in any other area of research that had a small population. If, on the other hand, you're talking about first-year law student experiences in New Zealand of arriving at law school, well, there's a heck of a lot of law students in a first year who have experiences of arriving at law school, right? So your potential sample there is huge. And if you're writing a piece that's saying, well, I've talked to 10 students, and this is their experience of arriving at law school in New Zealand and those experiences, and here's my article that is going to change our entire understanding of that. Well, if you only spoke to 10 students, then no, it probably didn't. So the context of what you're doing is important as well. So it isn't simply a case of smaller studies, no, big studies, yes. It has to be what you're doing with it and why you're doing it as well.
So again, just trying to think like for this audience. So if they're saying, yes, well, I do want to take the presentation I've given in this conference, or the sort of presentations that we might hear in Connecting Legal Education. And if the Law Teacher isn't the venue, I mean, do you have suggestions about where they should seek to publish?
Well, the honest truth is that journals are moving all in the same direction on this. So it is a case of, if you want to do it as a smaller, if you are only want to share that small sample, then it probably is going to be a blog, and that then provides a platform for talking to other people, or a shorter piece of writing that could be for the Law Teacher or for other journals. But if you are looking to engage with rigorous academic peer review pieces, then just as if you were writing in a contract law journal or a torts journal, then the same expectations apply in terms of rigor to legal education research. And so you do then need to think about, if it's empirical, the size of your study and what you're doing in scaling up your claims. It could be that actually that just doesn't work. And so really it's about locating it in a really rigorous theoretical framework.
Right.
That could be another way of going. It could be that you're seeking to locate it within a rigorous literature review. Right. But what does that mean? When we talk about lit review pieces, are we talking about, for instance, a systematic literature review and locating the piece that you're writing within that methodology? Or is it that you're just saying, this is a literature review, but it's not rooted in that? So it's really thinking through those questions of method and methodology.
So another question's come in from Esther, but I just want to slightly finish off the conversation again, because I think it has got real practical relevance for the people here. So what you're saying is that another route, if you haven't got the vast numbers and the statistical skills, could be to be you could be making a contribution in terms of saying, well, this is some pedagogical theory. I mean, this was my article, so Communities of Inquiry Pedagogy. And you could be saying, right, let me tell you about that and let me critique it and why I think it's relevant to practice. And that could be where that might still be of use to the law teacher or not.
Oh, absolutely, absolutely, very much so. And we would love to see more theoretical research coming through to us as well. So, and I don't want people to feel discouraged in all of this. I know that that might be the initial reaction. People are thinking, crikey, this sounds really tough and really difficult. Actually, it really is about thinking through this and breaking it down into simply, okay, what am I trying to do here? What is my method? What is methodology? As you would for any other form of legal education research. So for theoretical work, okay, how is this contributing to existing theory in this area? So it's probably doing a little bit more work then to look into those theoretical areas, a little bit more work in terms of the literature review. And again, if that feels a little bit daunting, you are not alone. This conference is bringing together a number of people who will, I'm sure, have shared areas of interest. And so contacting one another, sharing those areas of interest can then be a way that suddenly a 6,000 word article, you've got to do 3,000 words because you're working with another colleague. It becomes much less daunting. You can share some of those challenges with one another as well in terms of literature. You can split up how you focus on different aspects. And so what seems quite scary can become a shared experience that is much less scary. It is much more practical to do because we're working as a community.
There are a couple of questions, 3 questions, but before, I do want to just say, there's an example. We had a colleague who's now she's now at Aberdeen, and she published in the Law Teacher as part of a team while she was with us. She did a project, and one of the team was from our teaching and learning unit. And so by working, having people in our discipline working alongside somebody in the teaching and learning unit, that was a way of the sort of team you're talking about. Chris, let me tell you about some of these questions. So Esther, I have a question too. In Australia, teaching specialist positions are increasingly established. These members of staff do not normally have access to research resources like help with quantitative analysis. Would that mean that the people who do the majority of the teaching would actually not be able to publish about it because they lack the support? Or would you make an argument for upscaling or universities expanding access to upskilling or universities expanding access to resources?
Yes, so first of all, that's not a challenge unique to Australia. That is, a number of jurisdictions are going down those contractual pathways in their institutions with varying degrees of support. Personally, I feel very, very strongly that if universities are going down that route, then the support that staff who are focusing on teaching should be the same as staff who are supporting on research. It should be the equivalent of. So I don't think universities should be putting those barriers in place in terms of resource and support and so on. But let's do, so that's the, if I ruled the world, that would be the approach. But we have to work within the reality, of what institutions do provide. And I think it's worth saying that a number of institutional bodies, the Socio-Legal Studies Association, for instance, which does have Australian members as well as the Australian New Zealand Socio-Legal Society, they provide mentoring programs, that provide training grants as well, that people can bid for and access support where their law school doesn't provide that kind of training. You can also have a number of teaching focused scholar societies that do have similar grant schemes or provide through their conferences developmental opportunities for colleagues in that work. So I think you're right that those barriers are unfortunately there for some institutions, but I think there are some ways around it in terms of accessing that support. The flip of it, of course, is that the expectations in those institutions is not the same for the peer-reviewed academic articles to be published in the same way. That does, of course, create barriers for if people want to move to other institutions or shift contract routes that people are on. So hence why I think that all universities should provide those opportunities, right? Because otherwise you're locking someone in. But I do think you can access those opportunities through other societies, or it encourages society, if you're in a space where you don't have those, to provide that. So if your own institution is not providing that that support, then to ask the society to say, hey, actually there's a need here for a group of law teachers or researchers in this area to provide that training. And generally, I think they will, if they know that that need is there, if that audience is there.
Esther sent the thank you, Chris. Is that okay, Esther? Esther also sent the law teacher link, and I eventually managed to copy it into the chat.
Thanks, Michael.
After several attempts and copied miscellaneous messages as well. I think one thing that's very central, that's been recurring theme, is that, and it's a positive thing, is that we can do this if we work in community. And you've talked about communities like Connecting Legal Education. That's a group organised, I think, Michael Doherty, Lydia Blisdale and Emma Flint in England, and that people can join that and lots of presentations like these conference presentations. Of course, I think that our conference and our seminars are that kind of thing, communities where between us we can work out how to meet the exacting standards for law teacher. So would you agree that if we work together, that we it'll be fun, and we can do it?
Absolutely, Michael. And I think, again, I'm getting the impression I've terrified everybody about law teacher standards of this, and that was not my intention at all. I think the point, and Esther alluded to this as well, is that around the world now we're seeing different contracts, we're seeing huge pressures and tensions within higher education environments, and challenges about publishing legal education research and what that might look like. And rather than kind of running away from it or pretending that they don't exist, I think it's really important that we demystify what those structures are, what those expectations are. But then I think there's an opportunity, as you said, Michael, that through conferences like this one, we can collaborate with one another. Legal education, I think one of the things that marks us out as a community is we are incredibly supportive as a practical community and as a research community. We support one another. We're used to doing that, I think, not least because it's so inherent in much of our pedagogic practice as to who we are and how we go about things. And so by working together, by sharing the things that frighten us and scare us and confuse us, we can demystify those things, and we can also have, as you said, Michael, a huge amount of fun sharing these experiences and the excitement. You always see people talking about their experiences with students and how they can innovate and do different things. All of that is why we're here. Legal education publishing then can be a fabulous opportunity for people to do that collaboration and produce those outputs. Absolutely.
Terrific. Thanks, Chris. Well, I think we've slightly overrun the time, but then we started a moment or two late as well. So, Chris, very many thanks for the presentation, and hopefully we can hear you again, and hopefully we can submit to the law teach.
You definitely can.
Okay, great. So
Thanks, everybody.
Thank you.